Ladies and gentlemen, Devyo or Sajjano, a very good afternoon to all of you and welcome to this fifth in a series of webinars being organized by the Center of Excellence on Alternative Dispute Resolution at Manav Rachana University, jointly with UNCCI, which is UNCITRAL's National Coordination Committee for India. My name is Ajay Thomas, and I'm the Director of the Faculty of Law at Manav Rachana University. Additionally, I also act as an independent arbitrator, and I am also a national correspondent for India to UNCITRAL's cloud system. The topic for today's webinar, ladies and gentlemen, is very interesting. Mediation and arbitration, friends or foes? Ladies and gentlemen, I must at the outset say that we live in very, very interesting times. There was a time not too long ago when it was often said that mediation is mediation and arbitration is arbitration, and never shall the twain meet. However, in recent times, these rigid boundaries between mediation and arbitration have begun to blur, and the focus of this webinar to a large extent would be to look at those myriad ways in which arbitration and mediation could be blended into one seamless dispute resolution process. So on that introductory note, I now invite Mr. Gaurav Banerjee to deliver his opening remarks. But before he does so, I think it's important that I let you know a little more about Mr. Banerjee. Mr. Banerjee is a senior advocate practicing at the Supreme Court of India with an emphasis on commercial matters and in particular international arbitration. He is also a barrister with Essex Court Chambers in London. He studied law at Magdalen College in Cambridge, securing a first class in the law tripos. He was called to the bar in 1990 from Lincoln's Inn and has been practicing law for the last 31 years. Mr. Banerjee was designated senior advocate at the young age of 36, perhaps one of the youngest ever. He is a former Additional Solicitor General of India, having served the position with great distinction for 5 years. He is the Vice Chairman of the UNCITRAL's National Coordination Committee for India. And ladies and gentlemen, it is in this capacity that Mr. Banerjee will deliver his opening address. Mr. Banerjee, the floor is all yours.
Thank you, Ajay, for that florid description of my CV. As Ajay mentioned, I am here in my capacity as the Vice Chairman of the UNCITRAL National Coordination Committee. And you must be wondering what this is. We've done about 5 webinars along with Manav Rachana University. And in fact, this is our 9th webinar UNCCI is doing. And the reason that we are doing this apart from these very interesting times is that we are a recognized body of UNCITRAL, which as many of you know, is the United Nations Commission on International Trade Law, set up as long ago as 1966. And India was a founder member of UNCITRAL. So essentially what UNCITRAL does is it has various working groups, and it, as the title suggests, it suggests laws and model laws and such internationally, so that there is some sort of synergy. And our job at UNCCI is essentially to capacity build. And one of the areas that UNCITRAL has been looking at quite closely in the last few years is in working group 2, apart from the arbitration aspects, which all of you or many of you have heard of, is its focus on mediation. And particularly with regard to mediation, UNCITRAL has come out with a model law, but that's a little in the past, which has been amended in 2018. But the main achievement of UNCITRAL and indeed of the UN is the Singapore Convention, which is the United Nations Convention on International Settlement Agreements resulting from mediation. And interestingly, 53 countries have signed it. India signed it in June 2019. About a week ago, Ghana signed it. So there are 53 countries which have signed it, but only 4 or 5, I think Singapore has ratified it. So this is a new development, and this is relevant particularly to our topic, which is mediation or arbitration, friends or foes. And we are fortunate to have one of our speakers who will tell you more about the mediation convention. But really, the topic is very interesting, and I will not spoil it for you by commenting before the speakers have commented. But the topic is very interesting. Ajay mentioned east is east and west is west, and never the twain shall meet, that famous ballad of East and West by Rudyard Kipling. But you will remember that in the end, two men did meet at the end, and there was no division between two strong men. So now we have, in fact, a number of strong men and women who will speak and show us how these parallel lines actually meet. For me, as an arbitrator and more of an arbitration expert, the understanding has always been that mediation and arbitration effectively have in India run along parallel lines. And really there has not been that much interaction between the two. But now in the last few years, there have been so many interesting issues, and I'll just touch on some of them to give you the flavor before the meat of the matter is addressed by our distinguished speakers from across the world. There is a fundamental difference between arbitration and mediation. One of the questions one asks is, what are the features that an ideal mediator should have? Can an arbitrator who really looks much more like a judge who decides matters, can he be a good mediator? What are some of the factors? So maybe that will be explored by some of our speakers. Then we have all these funny names, these hybrid processes. Med-Arb, Arb-Med-Arb, Med-Arb-Med, nice mix, hybrids. How does this really work? I mean, a lot of interesting issues arise. For instance, issues of confidentiality arise. Issues of conflict of interest arise. Can the same person be an arbitrator and a mediator? Moving on from there, another issue, issues of enforcement arise. How do you enforce these mediated settlements? Can you go the arbitration route? What is the impact of Section 30 of our Arbitration Act, which says an arbitrator is to promote mediation, to promote settlement? I mean, that's really not happened in many of the cases where we've participated. What about Section 74? How does that play out? So conflict issues, enforcement issues. And then from the narrow perspective, we get to a much wider perspective. What about the international impact of mediation? How does the Singapore Convention play out? How does it help? There are older issues of the protocol, the SIAC mediation, the Singapore SIAC SIMC protocol. How does that work? So, ladies and gentlemen, there are a large number of issues, but ultimately the question that certainly I am looking forward to being answered by this distinguished panel is, are they really friends or foes, or can there be a mediated settlement between arbitration and mediation? And with that thought, may I please hand over back to our distinguished moderators. Thank you.
Thank you very much, Mr. Banerjee, for those very brief and very succinct introductory remarks. Ladies and gentlemen, we are indeed privileged today to have with us a superstar cast of speakers, which includes a man whose name is synonymous with arbitration and mediation. My apologies. A man whose name is synonymous with mediation in India, an acting High Court judge from the Balkans, who is also an active mediator and arbitrator. Then we have a very distinguished sitting judge from one of India's oldest high courts. And last but not the least, a man who for many decades was instrumental in steering global and regional efforts to promote institutional arbitration and also Singapore as an arbitration hub. He's a veritable fount of knowledge on all matters relating to arbitration and mediation. Now, that's the very brief introduction. Now, let me talk a little more about our distinguished panel of speakers. You might ask me, why do we need a more elaborate description of our speakers? For the sheer fact, ladies and gentlemen, that we have our audience today is a multinational audience, to a large extent from South Asia, but we have people who have signed in from all around the world. So, and also the achievements and the stature of our panelists today is such that I think they deserve a more elaborate round of introductions. Our first speaker for today, ladies and gentlemen, is Mr. Sriram Panchu, who is one of the very few internationally recognized Indian mediators. He took practice in 1976 at the Madras High Court and was designated a senior advocate in 1996. As a litigator, his primary field of practice is constitutional and commercial law. He has been in the forefront of the mediation movement in India for over 3 decades now. In 2005, he set up India's first court-annexed mediation center at the Madras High Court and has since assisted the Supreme Court of India and various other high courts in establishing our respective mediation centers. He's trained over 1,000 mediators and is a prolific writer, and his 3 books on mediation, Settle for More, Mediation Practice and Law, and the Commercial Mediation Monograph are authoritative guides on mediation in India. He's mediated a large number of complex and high-value commercial disputes in India and internationally. And more importantly, ladies and gentlemen, he has also been appointed by the Supreme Court of India to mediate significant public disputes, including a border dispute between 2 Indian states, the states of Assam and Nagaland, and in the recent past, the Ayodhya Ram Janmabhoomi Babri Masjid dispute. Mr. Panchu is a member of the National Legal Services Authority of India and the president of the National Association of Mediators of India. He's a director of the International Mediation Institute, IMI, and he also heads the mediation chambers in Chennai. Our second speaker is the Honorable Srdan Simac, who is a judge of the High Commercial Court of the Republic of Croatia, and he is also the president of the Croatian Mediation Association. He's amongst the leading mediators in Croatia with a unique personal approach to mediation. He has mediated many domestic and international commercial disputes and has helped hundreds of persons and companies to resolve their conflicts and disputes. Judge Simac is a very interesting person. In addition to being a judge, he's an arbitrator, a mediator, a mediation trainer, a lecturer, speaker, author, and essentially, ladies and gentlemen, a true mediation evangelist. He holds a PhD, and the topic of his dissertation was mediation as a generator of change in the legal system and the legal profession. He's an international mediation consultant with EBRD, CADR, and IDLO, and is on the panel of numerous international organizations, including ICSID, CADR, Prime Disputes, and JAMS, amongst others. Justice Simac's name also features in the Who's Who legal list of top international mediators. Our third speaker is Justice Maushami Bhattacharya. Justice Bhattacharya holds a BA with honors in English from Jadavpur University and an LLB from the Calcutta University. She read for her LLM from the University of Cambridge with a Rotary Ambassadorial Scholarship. Upon joining the bar, she practiced at the High Court of Calcutta, as well as the Supreme Court of India and various other high courts and other specialized tribunals. She has worked as an advocate under Justice Indira Banerjee, who is now a judge of the Supreme Court of India, and also with a man who's synonymous with company law, Senior Advocate Sudipto Sarkar from the Calcutta High Court. Justice Banerjee, during her time at the bar, specialized in corporate and constitutional law. She was elevated as a judge of the Calcutta High Court in 2017. And most importantly, ladies and gentlemen, she continues to inspire thousands of women lawyers in their pursuit for excellence in the profession of the law. Our fourth speaker, ladies and gentlemen, is Professor Lawrence Boo, whose name for decades has been synonymous with Singapore arbitration. Professor Lawrence Boo heads the arbitration chambers in Singapore. He's the former deputy chairman of the SIAC, the Singapore International Arbitration Center, and was also the first chief executive officer and registrar of the SIAC when it was established way back in 1991. And ladies and gentlemen, I also admit that I had the pleasure and good fortune of working under Professor Lawrence Boo during my 2 years at the SIAC, way back in 2007 until 2009. Now, Professor Boo has more than 20 years of experience as an arbitrator. He has sat in close to 300 cases under the rules of major global arbitral institutions as well as ad hoc matters. From a mediation perspective, Professor Boo is no stranger to the process of mediation, having mediated no less than 100 disputes with a great success rate of 75%. He is on the panels of leading international arbitration and mediation institutions. He is Singapore's nominee to ICSID's panel of arbitrators, as well as the national correspondent to UNCCI's cloud system. Now, ladies and gentlemen, last but not the least, you must be wondering as to who is that pretty lady in white on the screen. That pretty lady, ladies and gentlemen, is Advaitha Sharma, who will be helping me hold this webinar together as my co-moderator. Now, here's a little bit about Advaitha. She pursued her LLM in International Business and Commercial Laws from King's College London. She currently practices as an advocate in Delhi, and her practice encompasses the broad ambit of commercial law with an emphasis on arbitration and insolvency laws. And she is here essentially in a capacity as a secretary of UNCCI's National Coordination Committee for India. She is also a prolific author, having penned various articles on insolvency and arbitration laws published in reputed Indian and international journals. Now, ladies and gentlemen, before I invite the first speaker to deliver his brief opening remarks, I would like to thank Rashid and Live Law for being the media partners to this webinar. Now, may I invite our first speaker, Mr. Sriram Panchu, to deliver his opening preliminary remarks. Mr. Panchu, over to you, sir.
Thank you. Thank you, Ajay. Good afternoon, everyone. It's a privilege to be on such a distinguished panel, and I'm particularly looking forward to the presentations and discussions. My best wishes to everybody who's attending. Arbitration and mediation, friends or foes, strange bedfellows or harmonious partners. In earlier times, there was not much question. Arbitrators and mediators didn't quite see eye to eye. And on the face of it, it does look like there's a lot of dissonance. Here is arbitration, where the arbitrator has to make a decision. It's a formal process, and it's run on adversarial lines. And there is mediation, where the mediator makes no decision at all. It's entirely in the hands of parties. It's an informal process. It's voluntary. And it is the exact opposite of adversarial. It's consensual. So how are these two ever going to meet? The good news, and the good news for all concerned, is that current thinking points to convergence rather than divergence. I think we're in an age, whether brought on by COVID or even earlier, I think we are in an age where, we're all looking at new ways. We're looking at new ways. We're looking at new paths. We're moving to see what is beyond the tried and tested and the ordinary. And it's in that light, I think, that arbitration mediation is actually going to take off and take off quite strongly. So let me explain my proposition. Mediation is the latest kid on the block. It's very recent. It's barely since the 1970s since it started making its emergence. But in these last few years, it has become, I think, the fastest growing dispute resolution method world over. In India, its origin is it's 2005 when we set up the first center in the Madras High Court. But you'd be surprised to know that since then, it has rapidly traversed the length and breadth of this country. We have almost every high court now, and many district courts below have mediation centers. We have a few thousand mediators who conduct mediations in lakhs of cases, and cases of all varieties, cases of all types, with good rates of success. It is something which has caught on very strongly into the court system, and I think that's a good way to start, because we need, in a country like India, you must start something like this in the courts, then where people take to it. So it's very strongly established in the courts. There's no going back. We are now moving to the area of professional mediation or private mediation, where disputants can access a mediator before coming to court. And that in turn will fuel the rise of mediation as a professional practice. And in this, I think 4 things are helping us, and I like to call them the 4 beneficial horsemen of the apocalypse. We have very strong judicial support, which has always been there for court annex mediation and is significantly strong for private mediation, where senior judges are saying, don't bring matters to court. Resolve them if you can, and try your best, and come to court only if you cannot. That's a very, very strong message to send out. And soon I think the judiciary will look at more, stronger and more punitive ways of enforcing that message. The second is the Singapore Convention, because that convention has demonstrated to business worldwide that it is feasible to have a mediation settlement, and that your earlier apprehensions about enforcement are now not there, because you can enforce this convention in any country across the world which is a signatory, and it will be enforced without question virtually. You can have no better guarantee of enforcement. Mind you, 99% of mediation cases never go to court because people just act on them. Most people don't understand this. They think enforcement is there in all cases. No, 99.5%, they never get to court for enforcement. In my 30 years, I've never had one case where people have had to go and enforce it. They just sign the agreement, they hand over the checks, they do what's necessary. So the Singapore Convention is a big marker for business. The third is India's bringing into force of mandatory pre-institution mediation for commercial cases, which came into the enactment a year and a half back. We still haven't actioned it too well, but there it is, and it will get better, where commercial cases must run a threshold mediation before they can be lodged in court. There's an exception right now for interim orders, but that will get sorted out. So I think we'll have a regime, this concept of pre-institution mediation, pre-litigation mediation, and that's a very, very important concept to lodge in the mind. And the fourth is COVID. And for all the destruction that COVID has brought us, COVID is also teaching us new ways of doing things. And one is simply that we can communicate online so well. I mean, the number of webinars and conferences we've seen in the last few months, and we've always had this medium for years now. But see how well we're using it now, and how well we've caught on, and how simple and easy and effective it is. I would say especially for mediations, online works so well. So I think COVID, new ways of thinking, and this online dimension is the other big one. And I think with this, mediation really, these four steps that I mentioned, the four horsemen, mediation comes of age. I like to tell my mediation friends, I said, I have a new slogan now for mediation. Carpe diem, seize the day, because the moment is yours. The only way it's going to grow is to grow rapidly. Now, the good part about mediation is that it's not a displacer, it's not a disruptor. It is not something which negates other systems. And therefore, mediation exists and can exist quite well in harmony with arbitration. When you use them sequentially, one after the other, when you time them and say, well, on the occurrence of this, if this doesn't happen, we'll try mediation. Or through this, we will try arbitration. So when you sequence their use, you get that harmony. And the synergistic application of that, how there are synergies, I'm going to request Justice Maushami Patacharya to address that, the subject of, how do you have synergies in this? Let me switch to two other things that are important. The first is, in determining whether ArbMed is going to come in strongly or not, it's not mediators, it's not lawyers, it's not the courts, it's not anybody else who got to determine this. It is the users. The users, ladies and gentlemen, mind you, are now getting into the driver's seat. And they will decide which system to use and how much. And users predominantly all over the world are very, very clear when you ask them. They say, give us something which enables us to settle our disputes amongst ourselves the way we want and to get the solutions we want. If that doesn't happen, give us a system which gives us a verdict as soon as possible. That is what users want. And there is no better definition of ArbMed, MedArb, than to give you this. A system by which people can settle disputes amongst themselves, respecting their relationship and taking view of their problems practically, and if not, a verdict from an adversarial hand. There is one big issue, and which is really, I find, the principal problem factor when it comes to this whole the hybrid. Arbitration, mediation, can they go together? And I find that people get split on this because of one reason. And that reason simply is the neutral who's doing the arbitration the same neutral who's going to do the mediation? Or is the neutral different? If you think in your mind that the neutral is the same, then you have a problem. And the problem simply is this. The problem is one of confidentiality. Because anybody who has sat in mediation is privy to confidential discussions. Parties have opened their minds. They've told him things beyond the record. They've indicated what they may accept as a settlement. They may have tried to prejudice him. So anybody who's participated in a confidential mediation discussion as a neutral, in my view, cannot sit as an arbitrator at all, under no circumstances. And I think if that is clear, then the whole problem area vanishes. Because then you have a systems where you have an arbitrator. At some point when it is thought beneficial and necessary, the parties switch to mediation. And another person comes in as a mediator. And if you get a result, then you have a mediation settlement. If you don't get a result, the parties go back to arbitration, to their previous arbitrators, and there is no issue of conflict or disclosure of confidentiality. To my mind, that way it works well. So if we sort out that issue of confidentiality through the question of, is it the same neutral or not? I don't think we have problems. Last point, mediation and arbitration can combine at different stages. You can have a contract which says try mediation before arbitration. When you go to court to appoint an arbitrator, the court under Section 11 often does that now. So Justice Kaul started that practice in Chennai. where he said, I'm appointing an arbitrator, but I'll give you 1 month's time to try mediation. At any stage during the arbitration, the arbitrators can suggest to parties, the parties can request that why don't you try mediation? We'll keep the arbitration on hold. Even after a decision in the arbitration, you can still have mediation before parties head for court for the inevitable challenge to the arbitration award. And even after that first court ruling, you can have mediation any time. That's the beauty of mediation. So it combines beautifully and seamlessly with arbitration. And the other way around too, when you have arbitration, sometimes you cannot sort out a ticklish problem because there is a legal issue or there is an interpretation to be done. And you can't mediate it. Carve that out. Segmentize it, carve it out, send it quickly to arbitration, agree on an arbitrator, let the arbitrator decide that, let it come back, and you wrap it up with the rest of the stuff that you've mediated. So as I said, there are very, very interesting synergistic ways. There are some novel applications of this process, but my time has run out now. I'll come back to that if I have time later. So this is my opening. I think I've shot the mark by a bit. I beg your pardon.
Thank you, Mr. Panchu, for that lovely, for setting the stage for the future discussions and deliberations. Now, I had one follow-up question. As you are aware, we have the provisions of Section 30 of the Indian Arbitration and Conciliation Act, which talks about the fact that it would not be incompatible with an arbitration agreement for an arbitrator to encourage settlement of a dispute. And for those purposes, an arbitrator may use mediation, conciliation, or any other procedures to encourage settlement. Now, don't you think there is a sort of a disconnect between this and the confidentiality requirement, which is so implicit in the whole process? And how do you reconcile, Section 30 with the very basis of mediation?
Yeah, my answer is this. There are two ways of looking at Section 30. One is that the arbitrator is an enabler, and he enables the parties, he suggests to them, or he gives them the time, he gives them the space, he gives them the leeway to go into mediation and encourages them. In that way, there is no problem at all. The other is to look at Section 30 and think that the arbitrator can, in fact, do mediations and resume as an arbitrator if the mediation doesn't work. And I think that's a complete no-no. That flies in the face of every mediation concept. It flies in the face of justice as we know it. And I think it's an abusive process and it shouldn't be done. I'm sorry to use strong words. Let's also remember that Section 30 was drafted at a time when we had very little knowledge of mediation. 1996 is that act, and it's only in 2005 that this country really got to know what mediation is all about. So one shouldn't really impute to legislative makers such an extensive knowledge of mediation as to think that they intended that the arbitrator should mediate. And talking about legislative makers, can I share a small rhyme, a little rhyme? The little rhyme says, I'm the parliamentary draftsman. I make the country's laws. And if half the country's litigation, I'm undoubtedly the cause. So we must, put parliamentary draftsmen in their place. The courts are there to correct them when they go wrong. And beyond that, I think when we are framing a mediation statute, which there is now in the process, we'll correct this infirmity.
Great. Thank you, Mr. Panchu, for that clarification. And now, ladies and gentlemen, from India, we move over to the Balkans, the beautiful Balkans, and to the Republic of Croatia. Ladies and gentlemen, I now invite our next speaker, the Honorable Srdan Simac, Honorable Judge of the High Commercial Court of Croatia, to deliver his opening remarks.
Thank you, Ajay. I'm pleased to be with such distinguished speakers and moderators and attendees. So, as you have mentioned, the topic is very nice, and I would like to express some general remarks about my views toward cooperation in ADR field and the field of dispute resolution, and towards need of adjustment and development of legal practices So want we admit or not, definitely there are many tensions between or among dispute resolution world among people. So the mightiest tensions is still the tension between traditional dispute resolution world and ADR dispute resolution world. And above that, there are a lot of tensions among different ADR approaches, so including mediation and arbitration. So there is, of course, a natural, a common tendency to define ourselves through our desires, beliefs, values, interests, and of course, criticize others who don't fit. So we all are usually proponents of ADR practices we prefer the most. But I believe that there are like in conflicts, there is that we can find a lot of good in tensions in ADR field. Mary Parker Follett once said, "All polishing is done by friction." I like that quote. So the consequences from these tensions can be serious only when we come to the point of advising our clients which ADR approach they should choose as an option. Of course, they count of our professional objective and independent judgment, and they count we are going to protect their interests and needs, not ours. So if we want to help our clients and ourselves, I believe we have to advocate a greater acceptance of diversity in dispute resolution. As you know very well, there is no one approach fits all, and you know, more choices, better decisions, better outcomes, and every method in dispute resolution world has some advantages comparing to others in some circumstances. I believe that today are all of them somehow interdependent. So I believe that all of us should stop to be or act as rivals or competitors in a dispute resolution world and become collaborators like we do today. So, you know, arbitration and mediation came to the reality at some point, one before the other, because of the widespread dissatisfaction with the traditional dispute resolution systems. So today, everything has changed, but still traditional dispute resolution system very little. So I like that somebody compares mediation with the sleeping giant who is awakening, and its advantages in many disputes and for many disputants. I see that they become so influential in dispute resolution world and acts as generator of change in law, among lawyers, among legal institutions, and including arbitration. So the common denominators for all these approaches I see besides the clients are lawyers, a legal profession in general. They are in the middle of all changes. We lawyers, we can choose to the role of be gatekeepers of changes or gate openers. So it is evident that even today, probably the most of our colleagues trying to keep status quo, yes? And even in ADR field, traditional lawyers somehow transform arbitration from really beginning, and step by step, traditional lawyers stole its soul, I can say. And then, especially in the United States, they want to change a mediation, trying to convert it to another legal process and subordinate it to their own needs. So I would like to stress where are the client's needs. So the most important stakeholders, like colleague Panchu said, in dispute resolution world are the clients. So they cannot stand anymore traditional legal approaches and the high level of control of them by the lawyers. They cannot stand anymore and hold those lawyers who cannot adjust to the new reality and the needs of modern users and societies. So I am, and probably you are, witnesses of the users, clients, especially business one. They are trying to replace all those who cannot follow their needs and interests. Even lawyers offering legal services who cannot follow that. So they started to not use legal approach as much as possible. So I firmly believe that we are here all representatives of the legal profession who are actively aware of the need to adjust, adapt, and change to a new reality. We all here do that or doing that. We are in the moment of unprecedented demand for change in the history of the legal profession, and we should accept it with open arms. And we need definitely and immediately to work on improvement of users' experience of legal services. So I can say that I am a real example that is possible. So can you imagine my path from the strict and formal judge who was thinking that he is born to be a judge, then to an arbitrator, maybe improved version of the judge, and then to the mediator, and then to the mediation trainer and promoter. And I think I don't need to tell you which one role of these I prefer the most. So I can say I am the one, as my distinguished speakers are too. I am a legal professional under the process of evolution. So from the moment I have opened my personal and professional mind to the new multidisciplinary world of knowledge, skills, and experience, especially all those who are coming from the mediation world, I become a better professional, a better judge, and what is the most important for me, a better human. And from my standpoint of view, it really works. Thank you very much.
Thank you, Justice Simac, for those introductory remarks. I had a follow-up question, Justice Simac. Now, you have the unique fortune of acting as a judge, as an arbitrator, and also as a mediator. Now, it is said that judicial mediation has been hugely successful, not only in civil law countries like your own very jurisdiction, but also in some common law jurisdictions, for example, Australia. So, however, there is a school of thought which says that involving judges in mediations, especially when judges are acting in private sessions or caucusing with parties, this might be somewhat incompatible with the constitutional role of judges. And this might result in the blurring of boundaries between judicial services and non-judicial services. So your views, Justice Simac.
Yes, thank you, Ajay. It's a fine question, and it's a very common question. Somehow people still see judges as some kind of superhumans, supermen or supergirls who cannot act anything than judge, to be a judge. So I used to be in a position that somebody called me a strange judge or an abnormal judge. So it is not the, I think that it is not dependent on the position you are acting in your professional life, but it depends on yourself as a person, as a human. So I really believe, and I have a good feedback about that, that I am among fortunate ones who can change hats. So a judge, arbitrator, mediator. It's not easy, and I work a lot with the legal professionals how to change the way of thinking like a lawyer. So the thinking of like a lawyer or as a judge is not my identity. It's just part of my profession. So I am much more than a judge, than a lawyer, than a part of legal profession. So I think relating of those who are skeptics about judge's ability to be a mediator, that could be partly true, because judges are in amazing position, trained to be in the middle. So they are not taking sides, and they can be really the best mediators or the worst if they cannot change judge's head for the mediator's one.
Thank you so much, Raj, for that insight into, the justification of how you can, you switch between those three hats of being a judge, a mediator, and an arbitrator. That's very, very insightful, especially for a lot of people from jurisdictions such as India, where it's unthinkable for a judge, as long as there's a sitting judge, to be acting as an arbitrator and also as a mediator in a formal capacity. So do we have Advaitha? Advaitha, are you on the call?
Yes. Now, can you hear me? There was slight disruption.
Yes, Advaitha, the floor is all yours.
All right. Thank you. Sorry for there was some internet issue. Well, thank you, speakers. And moving on with our webinar, I would now like to invite Justice Patacharya to share her practical insights and knowledge on the theme. Over to you, ma'am.
Good evening, my very distinguished panel. Am I audible? Is it clear enough? Yes. Justice Simac, Professor Bu, Mr. Panchu, Gaurav,
yes,
Ajay, Advaitha, thank you very much. I propose to distribute my opening remarks into broadly two categories as of now, and the way forward as to how we see the future, perhaps at a later time, if there is time at all. So let me first start, as Mr. Panchu kindly asked me to discuss the broad concepts of what an arbitration and what mediation is. As you all know, I don't really have to tell you the statutory framework of an arbitration. Suffice it to say that an arbitration is primarily viewed as a consensual dispute resolution, ADR in that sense, because the focus is on the party's will, the party's choice of forum, choice of arbitrator, apart from those which go to a court under Section 11 for appointment, but absolutely the parties' wish as to who they want to go before and where they want to go, as in venue and choice of arbitrator, and also gives them the consensus to decide whether an agreement and which part of that agreement is good enough to arbitrate. Apart from that, the most significant part of an arbitration is that it is guided entirely by the Arbitration and Conciliation Act 1996. So therefore, whether the freedom of the parties is real or perceived is something which we have to see and hopefully will develop in the course of the discussion. The Arbitration Act is an extremely structured enactment in that sense, right from the choice of arbitrator, venue, place, termination, the mandate, neutrality, which actually part of which came in after 2015 amendment, the enforcement part, the challenge to an award, the setting aside, everything is to be found under the Act. So in that sense, arbitration is really, although the consensus is inbuilt into the concept of arbitration is something which parties will really have to go back and rely entirely on the provisions of the 1996 Act. As opposed to arbitration, I really don't want to dwell too much about arbitration because that is something which all of you know. Mediation is something which it was very enlightening to hear Mr. Panchu on it, and he's an authority on mediation. I just wanted to add something. You know, when we talk of mediation, I think India occupies a unique position when it comes to mediation because of Mohandas Karamchand Gandhi. In fact, Gandhi positioned himself as a mediator, not only between the Congress party and the government, but also when it came to the Zionist cause in Palestine in way back in 1937. And in fact, I had occasion to read parts of a book. I think it was I'll give you the name, but it was written about Gandhi's mediation and his role in the Zionist cause. And in fact, he was convinced by one of the, I think Hallenbach, his name was, who was a prisoner for a couple of years. And Gandhi came to the conclusion, which is important in my discussion, is that there are three important features or aspects to a mediation, to a successful mediation. One is the timing. Second is to get everybody, all the parties involved together when the time is right. And number three is consensus building, that all the parties who are involved in the process should be on the same page. So it's not one person calling the shots, which is really the essence of mediation. The other interesting part which I always thought about is that arbitration involves a lease. After all, it's a dispute. It's completely adversarial in nature. It is like any other court matter. There are two parties, there are multiple parties fighting for their rights, for enforcement of their rights, trying to come to some sort of a conclusion, some sort of a restitution, but absolutely based and grounded on the provisions of the 1996 Act. So in a way, when the ultimate objective of the parties to an arbitration proceedings is when the award is enforced. So that is the finality which the parties look for. I mean, that is the end objective. So in that case, it is the end of a lease, so to speak. But as opposed to an arbitration proceedings, in mediation, the most happy part is that the dispute itself comes to an end. it is eradicated for all times to come, hopefully, of course. I mean, that is in an ideal state of affairs. So in that sense, it can be called inquisitorial, because it is between the mediator, the neutral, and the parties before him. And the objective therein is that the entire dispute should be eradicated. And in a way, I was reading some articles for the webinar, which says that it is a negotiated settlement. Even though the term suggests some sort of a negotiation, as if there is some sort of a compulsion there, but not really. The ideal mediation would be that the parties are on one page, are in complete agreement as to what are the things they want resolution of, and that is something which sets the process of mediation apart from any other ADR. And it is a great thing, really. In fact, going back to Gandhi, I think this one of the great effects of Gandhi is the Panchayati Raj system, and that is also something which is inbuilt in the constitution, was in fact formalized by, I think, the 73rd Amendment in 1992, which brought in the Panchayati Raj system in India, and which is really the smallest unit of local self-governance in India, where disputes are settled in an informal manner. There's a mediator, villagers come together, they sort out their differences, and that is, I would say, a very, very effective impact of what Gandhi really did for the mediation movement in India. When it comes to a comparison, whether mediation and arbitration are friends or foes, as in whether there's a tension between them or whether they can happily coexist, I would really hazard to say that now, in these extraordinary circumstances, we don't really have a choice. We have to and we must resort to all kinds of, or rather I would say any available alternative dispute redressal system, which gives redress, which gives relief to the parties. I mean, I would even go as far as using the analogy that mediation, arbitration, perceived tension between them would be like saying which is better. Is physical hearing in court better, or is online hearing of cases better? This kind of tension or this kind of juxtaposition doesn't really mean anything, because it all depends on how emergent the situation is. And to my mind, we are going through a time when we really don't have a choice. Mediation, arbitration, I would say, are the best suited for that purpose. Online facilities, anybody who has access to even a smartphone, anybody who has good infrastructure at home, at court, in chambers, workplace, it is the best suited medium, as opposed to court processes, where of course in my high court now we are going ahead with what we call a hybrid method, and we will be coming to hybrid methods. Mr. Boo will enlighten you all about it. Hybrid methods, as in, there's some amount of physical hearing, some amount of hearing online, and in most cases both happen simultaneously. So the only difference would be that we don't really get to choose as to which cases would be suitable for an online and which cases would be suitable for a physical hearing. But apart from that, I think it's really something which there should be no tension, no juxtaposition, no uneasy coexistence anymore. But any system which facilitates parties and litigants of towards reaching their goals, in solving, in coming to some sort of a resolution of their disputes, should be the order of the day, and much more so now when the world is going through what we are. And of course, the other thing I wanted to say is that I heard during the discussion right now that the court systems is so overburdened. I read somewhere that I think per judge now in the country, I think there are about 1350 cases assigned, which of course is a huge amount. And I read another statistic. I'm grateful to my juniors and interns for it. That now in India there are I think 18. That's 18 judges in a million people, compared to 56 in the United Kingdom and 102 in the US. So you can imagine. I mean, if we don't look forward and if we don't develop this field of arbitration, mediation, more so mediation, I would say, because mediation is really away from the courts, then there is really we are looking ahead to a very uncertain future. Having said that, arbitration, if not conducted properly, would be subject to the same afflictions which any adjudicatory system is subjected to, which is A, expense, B, delay, and C, quality of legal representation. There are of course other disadvantages, but these three are the primary, I would say. And the other unfortunate point which we see now more than before is that if the lawyers involved give honest and complete advice to the litigant as to the time duration, expected time duration which the arbitration would take or the mediation would take, then I think a lot of afflictions would really automatically disappear. What happens here is that lawyers, unfortunately, I mean, I can also understand their compulsions, particularly now, but if you do not give a correct estimate of how much time a mediation will take or an arbitration will take, or given this entire framework of setting aside under 34, challenge under 37, enforcement under 45, 46, 47, etc., then how will a party, how will a litigant decide as to which is the best course of action for him? So that is something which I think, and unfortunately in our country, for poor or incorrect advice, there are no consequences which follow, like they do in UK, I suppose. So therefore, I think the whole system has to be rethought as to what is the most effective way of getting ahead with it, so that the litigants know exactly what they are getting into. I think that really would rid the system of very many of the drawbacks. And the last part which I would like to address is that the Arbitration Act also has some weak areas, like presently a weak cost regime. Very few arbitrators go ahead and impose heavy costs on parties who either choose to go back and forth to the courts, either for the slightest pretext, whether it's under 17 or it's 27 or it's 16 or anything, 14, I mean, you name it. So this constant back and forth really inflates the time limit beyond the party's comprehension. So that is something which even a section 29A, which initially everybody thought, for those who are not aware, 29A of the Arbitration Act 96 is something which fixes mandatory timelines for the arbitrator to give his award. And 29B is a fast track hearing. So these two were very progressive enactments or very progressive provisions which were brought into the Arbitration Act in line with the Commercial Courts Act. Incidentally, the 2015 amendment in the Arbitration Act and the Commercial Courts Act were both introduced on the same day, which is, I think, 23rd October 2015. And the goal post of that was the quickest possible resolution of all disputes. So for a 29A to be effective, where a party comes to the court to say that you please issue certain directions on the arbitrator to complete the hearing and to give the award, the whole proceeding must be an honest proceeding. We have seen cases where the party complaining of a 29A has been somewhat influenced by the opposite party. So there, even there's an agreement between the parties that no, very well, we don't mind, the arbitration proceedings can continue for a while. It's okay. The dispute is very complicated, voluminous documents. So this will take time. So the point is that for these progressive provisions to have any kind of real effect, there has to be an honest effort on the part of the lawyers, on the part of the litigants, to really see to it that the both arbitrations as well as mediation, any kind of ADRs, reach their conclusion in the shortest possible time. I will just quickly touch to the other part which I wanted to really mention, is what are the qualities or skills required of a good arbitrator or mediator. I will not really hazard too much of a mediator because I can see Mr. Panchu, and he will be the best person to tell you. But with regard to the arbitrator, as to what would be a necessary skill set for a successful arbitrator, would be the indicators would appear from the Act itself. I mean, if you have a look at Section 31 of the Arbitration Act, which tells you what an award should be, what an award should contain, like it should be a reasoned award, 31(3). If you look at 34, which deals with what are the grounds for setting aside of an award, that would also give you a quick checklist of what are the qualities or what are the skills one is looking for in an arbitrator. Reasonableness, the ability to reach a decision quickly, and a knowledge and awareness of what the laws in the country are now, so that nothing is against public policy, nothing is against the laws as they are at the present moment. A fair idea as to what would be patently illegal, what would be against natural justice. We would find echoes of this in various other sections of the Act, like Section 18, which deals with, every party should have a fair opportunity to present his case. That is also part of Section 34, the first part. And apart from that, the arbitrator should also have an idea as to certain other very important provisions, like Section 7581, as to what are the confidentiality provisions, whether the arbitrator should make public, should disclose materials, or the mediator, more importantly, because there really are very contentious family or abduction or custody issues before the mediator, whether those should be made public. And in fact, those issues of confidentiality came up recently in a 2019 judgment decision of the Supreme Court, which is Perry Kansagra and Madan Kansagra, which is of 2019. I have the SCC online, and that was given by Justice UU Lalit of the Supreme Court. And in fact, over there, the entire discussion was that despite ICC rules and of mediation and family courts rules and provisions, whether the court can, in certain exceptional circumstances, disclose certain facts. And the Supreme Court came to the decision that the court can, because the court is in the nature of a parens patria, as in, as if the parent of the child in question, it was a question of custody in that case, and that the Supreme Court came to that decision. And we have other decisions also. In fact, I was looking at in Re D, a Child Hague Convention, which is of a family division court decision of 24th November 2017, where also the English court came to the decision that no, even though proceedings are to be kept confidential, and that is the broad framework of the legislation, there may be exceptions when certain facts would have to be made public only where it would secure the welfare of the child, which was supposed to be of paramount consideration. And there are other Supreme Court decisions also on that effect. And the last part of the skill set, which I would think is the most important, is impartiality and independence. This now is part of Section 12 of the Arbitration Act 1996, which really gives a very particularized framework of what impartiality and independence is to do, is all about. And it makes a very clear distinction as to three heads: any connection or relationship with the arbitrator as regards the subject matter, A, B, party, and C, counsel. And I think this is a very, very good framework, followed by the finer details in the 7th schedule and partly the 6th schedule also, which tells you really that, you know, all the possibilities, all the possible situations when an arbitrator can be said to have even a perception of the slightest connection with the subject matter of the dispute, previous connection, familiarity with counsel, with the advocate on record, everything. And quickly, I'll mention just 2 or 3 important cases for the benefit of the viewers, so that, you know, it just grounds it in not only in statute but also in case law, India being a common law country. So the first important case was TRF and Energo Engineering, which is of quite recent, actually 2017, 8 SCC 377, where the Supreme Court held that it was a managing director in that case, that once a managing director who was eligible to act as the arbitrator lost his eligibility, he could not appoint somebody else in his place to act as the arbitrator. So thereby, you know, a very important decision, important ramifications. And of course, it spoke of the 7th schedule, items 1, 5, 12 of the 7th schedule. All those of you who have the book in front of you, you can see what those items are. The second is the judgment in Perkins Eastman Architects versus HSCC, which is of also 2019, very recent in that sense. 2019 SCC Online 1517, which clarified TRF and held that this whole provision or this exclusive giving of a right to a party to appoint an arbitrator or a sole arbitrator cannot be supported if you are looking for a complete norm of impartiality. That is the second case, which is important. And the third case, which is of Westerpleen, Shinen GmbH, which is of 2017, which dealt with a case where there was a panel of arbitrators. So how do you choose, if there are a panel of 3 or 4 arbitrators, how do you choose who is the best suited for your purpose? And the Supreme Court prescribed that the category of persons should have certain basic qualities which would make them eligible to be empaneled, and also said that these categories of persons should have certain very distinguished qualities and should be of high repute, so that it would make them above any kind of perceived perception of bias. And the last decision I quickly wanted to mention is where this broad-based panel was discussed, is DMRC Central Organization for Railway, that is of 2019 again, where the Supreme Court mentioned and relied on Perkins and said that if there is a factor of choice of a person to choose amongst a broad-based panel, then that really would not impinge on Section 12 or the impartiality or the independence of the arbitrator. So I think I may have overshot my time. Apologies for that. But with regard to the way forward and certain other aspects, I would love to come back if there is time. Thank you very much.
Thank you, Justice Patacharya, for this intriguing and a benefiting perspective. Indeed, arbitration and mediation can and in fact should coexist. Stemming from your speech, I am inquisitive to ask few questions to you. My
Yes.
first question is India-specific question. In the Indian context, settlement agreements by way of private mediations, except the ones that are court annexed, have to be enforced only through courts like any other contract. Might this be one reason why mediation has not gained the requisite momentum in India? Over to you, ma'am.
I would really hazard an answer on in just one line, is that the public perception is that one of the main problems of mediation, or rather private mediation, is the absence of a relatively simple and a straightforward mechanism of enforcement. And something which really, and Mr. Panchu will correct me, something which sometimes acts as a dampener to a prospective party who would whose case is best suited for mediation. You know, amongst the cases I was reading today morning, there was one of abduction, many on custody, which are ideally suited for mediation. And in AFCONS, the very illuminating judgment of the Supreme Court, we know that there are certain, I think paragraph 24 of AFCONS gives this entire range of what can go to ADR, what kind of agreements cannot go to ADR, so on and so forth. But I think what really matters is parties must have that confidence that whatever is decided in a private mediation will be enforced or can be enforced by way of a legal mechanism or by way of a statutory framework if the need arises. Having said that, I would also say that Section 89 of the CPC, which is our base statute on mediation, that mentions court, and that mentions 89D, I think, that mentions court and that mentions compromise. So my personal view is that even though this is a public lack of confidence, as in the statutory, as in the absence of a statutory framework, my personal view is that the moment you impose a statutory framework on parties when it comes to mediation, that would also take it out of this entire freedom and consensus aspect, which is so unique and special to mediation, and which is really not there in arbitration proceedings, because in arbitrations you have to go back to the court, you have to go back to the statutory framework at each and every stage. So I think, to answer your question, this is one reason why parties really are encouraged to a certain extent of going for mediation, and also this nagging apprehension that if we have to go to court, or if we are dragged to court, then we will be subjected to all the downsides which a court proceeding involves, or at least in public perception involves, of delay of enforcing, etc., etc., etc. Thank you.
Thank you, ma'am. I would request Panchu sir to please comment. Sir, I believe you are muted.
Can you hear me?
Yes, sir.
A very quick response. Justice Patacharya is right. There is a perception that private mediation agreements can't be enforced, unlike the settlements in court annex proceedings where there's a directional decree of court. We have tried to get over this by using Part 3 of the Arbitration and Conciliation Act. As you know, Part 3 provides for conciliation. And the way we have found working with the AFCON's judgment is that mediation and conciliation are virtually synonymous. And therefore, a mediation agreement deserves to be treated on par with the conciliation agreement, which under Section 73 or 74 of the Arbitration Conciliation Act has a status equivalent to an arbitral award by consent, and therefore capable of being implemented by a court. So this is the way we found. It's a bit of a, it's a bit of a jugaad. Yes, it's a bit of a jugaad formula. Make do with what you have, but we are now correcting that in the legislation which is being worked on.
Right, sir. Thank you, sir.
If I may just add
Next,
to
I
that,
have the opportunity.
sorry,
Sure,
if I may
ma'am.
just add one
Sure,
line to that.
please.
I believe there's a recommendation by Justice Sri Krishna Commission as to introducing certain facets to facilitate mediation and a statutory framework for enforcement of mediation and decisions in mediation.
Yes, there is. Yes. There is, just Patacharya, you're right, there is. And it's at an active stage of consideration now, formulation of the draft act.
Thank you.
Thank you, ma'am. Thank you, sir. Next, I have the opportunity to now to our next speaker. And now I have the opportunity to invite Professor Bu to share his thoughts on the theme today. Professor Bu, over to you, please.
Thank you. Thank you. I was just very thrilled to hear Mr. Sriram, Panchu, and Justice Patacharya sharing observations earlier. In fact, Mr. Sriram Panchu so accurately says that the problem of enforcement is actually, and Justice Patacharya also, there is a perception rather than a real problem, because of the number of cases that have actually been mediated. Very few of us who have mediated such cases actually know of parties actually going to court for enforcement. As he has rightly observed, 99% of the cases that went for mediation and resolved in mediation never end up in court litigation. So it is a perception. In fact, it is a wrong perception that we must correct, that there is need for enforcement. I would suggest that the need for enforcement was a lawyer's thought. We lawyers actually introduced the concept that maybe we should have a method or process for enforcement. And that's why perhaps a lot of people view mediation as a poor brother of arbitration. But I must say that today's topic is very accurate, a very wide, properly framed. Is it friend or foe? My short answer to it is that it's definitely friend and not friend and foe. Addressing then the question of how then can you overcome this perception, so then we should provide a way of enforcement. So what is happening now is prior to the Singapore Convention, attempts have been made to try to say that, well, you can have a settlement agreement converted into an arbitration by appointing an arbitrator and then make the arbitrator grant an award by consent. This, however, meets with a serious problem of whether you can commence an arbitration when there's actually no dispute, when parties have resolved the dispute. How can there be an arbitration with no dispute, with an arbitrator being asked merely to sanction an award, which does not need to apply his mind, his judicial mind or quasi-judicial mind to adjudicate the merits of the case, and just to simply sanction the award. So whether or not such a document can really be called an award for the international enforcement is really a serious question. I'm talking about international enforcement. There could well be domestic legislation that can clothe such decisions or such awards as enforcement. That's possible. As what we have in India and what we have also in Singapore. So that's why there's a need for the identifying this particular lacuna or this particular weakness in the arbitration or mediation link. We in the SIC and SIMC in 2016 came up with this formulation called the ARB-MED-ARB protocol, which tried to address this issue for international enforcement. This, of course, requires the commencement of an arbitration, and then parties, after commencing arbitration, the arbitral tribunal will stay the arbitration process for parties to go to mediation. And when the mediation succeeds, the settlement terms then come before the arbitral tribunal, who will then make an award upon the terms. If it thinks they are arbitrable, if it is satisfied the award was made by consent, if it is satisfied that there's no public interest or third party interest involved, he will then sanction and make an award on such terms that may be arbitrable, and therefore make the award based on those terms. So this overcomes the problem of having a mediation and then commencing an arbitration, because in this process, the arbitration has already commenced. There was a genuine dispute at the beginning, and it ended up in a consent award. So this is what we call the AMA protocol, which came up in 2016. I must say that it has received very positive feedback following its launch. There have actually been agreements adopting the AMA protocol clauses in their contracts. And more recently, there are cases that were matured into disputes and referred to arbitration and the AMA protocol. I do not have exact numbers, but I can say that numbers are few that have come through the AMA protocol. A very positive response, but cases have not been plentiful in that sense. Let me say that the AMA protocol is only a temporary measure. It probably will be useful for another 10 years. Because what the AMA protocol does is to soft wire the mediation to the arbitration process. So that in this way, it makes the arbitration process result in a final award made by an arbitral tribunal. That's why it's quite exciting to see the Singapore Mediation Convention coming into force very shortly in September this year. I think Mr. Banerjee earlier told us that 53 states have signed on to it, including India, but we have received so far to date 5 ratifications. All you need is 3. Now we have 5 ratifications, so it will come into force in September this year. The Singapore Convention create a new regime for the enforcement of mediated settlement agreements without having to go through the whole process of either suing on the agreement or to convert it into an arbitral award like the AMA protocol attempts to do. The convention only applies for international cases. In other words, if it is purely a domestic mediation or domestic dispute between 2 Indian parties, a subject matter in India, then it will not come within the framework of this convention. And also it must also be noted that the convention does not apply to settlements reached in pending court proceedings or mediation sanctioned by courts. So in India, you may have programs sanctioned by courts called the next mediation. If you reach settlement, those settlement agreements will not come within the framework of the mediation convention, because if a judge makes a judgment based on the mediated settlement agreement or make it enforceable as a court order, then it also will fall outside the mediation convention. So this is the basic understanding of the basic framework of the mediation convention. There's also an exclusion, and that is if parties proceed to mediation and then the mediator must adopt only facilitative processes, because the convention defines the mediator as one who lacks the authority to impose a solution. So we must be very careful when we talk about mediation in the international context. The Singapore Mediation Convention only enforces settlement agreements that is mediated under a facilitative framework. The mediator must specifically lack the authority to impose a solution on the parties. This gives a little bit of a problem, because what if the parties agree that he lacks authority, but in the course of the mediation, the mediator sort of imposed a solution on the parties, and they sign off the settlement agreement, and subsequently one of the parties says, I was forced to do so. So that might become a little bit more problematic. But I think the whole idea and whole underlying concept under the Mediation Convention is to encourage the use of facilitative and not evaluative process of mediation. So, but this, as I say, may raise some problems when it comes to enforcing the mediated settlement agreement. The convention tried to adopt the framework that is set out in the New York Convention to provide situations where certain mediated settlement agreements may be refused enforcement. So the discretion is always to the courts that is considering the enforcement of the mediated settlement agreement. The usual problems that could be raised of the incapacity of the parties, or that the agreement is the mediated settlement agreement is null and void, incapable of being performed. Words that are borrowed actually from New York Convention, yeah, or that it's not binding, it's not final, or that the terms are unclear, or that it subsequently have been modified by the parties. So, or there's internal conflict in the mediated settlement agreement. The terms of the settlement are unclear, or they are internally conflicting. Or sometimes the terms call for performance that may be contrary to public policy, or they fall outside. Certain subject matters are not capable of mediation under this convention. For example, family matters, very domestic issues like custody, these kind of things are not actually capable of mediation under this convention. And two other grounds that may be problematic is that the mediator breached standards applicable to him. Yeah, the only thing that I can think of, meet standards applicable to him, maybe he has not had the pre-qualification to be a mediator, or that he has adopted evaluative or imposed a solution on the party which the parties didn't like but felt that they were forced to do so. So the power structure may sort of alter that kind of solution. So that may be a complaint that a party may bring, and that could well actually fall within one of the grounds for refusing enforcement. Yeah. So another one that I think is problematic is that it says that if the mediator failed to make certain disclosures, we know there's always an obligation to make disclosure of conflict of interest, relationship with the party or the subject matter. But failure to make disclosure itself in arbitration is actually not a ground by itself to set aside an award or refuse enforcement. But here, the failure to make proper disclosure becomes a ground. So that is a little bit more tricky. Instead of saying that if the mediator is found to be found himself in the circumstances that is biased or he lacked impartiality, here it is not an objective test. The test is if he fails to make disclosure. Of course, the disclosure may then give the excuse by one party to say, had he or the mediator, he or she not disclosed this matter to me, I would not have entered into the settlement. That could well be an argument, a serious argument that could arise from this ground, failure to make public disclosure. So very quickly, that's how I've gone through the mediation convention. I wonder whether there are any questions from any one of you. Thank you.
Yes, thank you, Professor. This has clearly helped us gain an international perspective on the theme. And I would now like to bother you with one question. How has the Singapore courts dealt with the enforcement of awards where the same person acted as arbitrator and mediator?
Have Singapore courts dealt with that?
Can you hear me?
Yes, yes. Have Singapore courts dealt with enforcement of awards where the same person acts as arbitrator and mediator? The answer is no. I have not come across any case this actually happened. But let me just respond to what Mr. Sriram Panchu earlier said. He said that he expressed grave concern about an arbitrator acting as a mediator, and that is a totally no-no. But let me say that this is probably our common law upbringing. Our common law upbringing sees that this is totally abhorrent to arbitration, an arbitrator acting as mediator. And there are some systems that don't see this. Yeah, I know that in China, for example, you don't see this. And in fact, the Germans, civil law jurisdictions like Germans don't see the same thing. In fact, I've sat in an arbitration where one of the German co-arbitrators then, after hearing the substantive argument, say, hey, let's think about it. What do you think? Shall we call the parties in to let them have an idea of what we think we are going to decide and see whether we can help them negotiate a settlement? So you see, they think differently. So to the Chinese and to Germans and to there are some jurisdictions that say, what is the problem here? Our problem is confidentiality, right? We talk about, oh, we need to maintain confidentiality. How can an arbitrator, a mediator, subsequently be a judge again because he's exposed to confidential information? The argument of the Chinese is this: what is the role of an arbitrator? The role of an arbitrator is to dispense justice between the two parties, to come up with a just solution. What is so wrong to have the arbitrator know everything about the case? Why are you hiding behind confidentiality? In other words, you are saying that the arbitrator should not know certain things so that he will not dispense full justice, just justice in favor of one party. So you see, the thinking behind is very different from what we are used to in common law. I'm not sure whether the Croatian Court Justice Simac may later share their views as well, because we bring into mediation and arbitration a very common law flavor and baggage. To me, it is a baggage. I learned to dislodge some of the baggage nowadays. And you'll find that in Singapore, we have the same struggle. We have a specific provision under Section 17 of our International Arbitration Act, allowing international cases for arbitrator to switch to mediator and then switch back as well. Yeah, I have tried in 2 cases, not successfully, because I find as a common law trained lawyer, I cannot switch like maybe Justice Simac can. I cannot switch from mediator to an arbitrator again, because I'm very conscious that I heard something from a party that will influence my decision. But the Chinese and the common law, civil law lawyers may say, what's wrong with that? You're supposed to know everything. That's why then you can dispense a better judgment. So here is a different way of thinking that we got to rethink. And I want to also draw attention to Article 13 of the UN Model Mediation Law. That's just came out, amended in 2018. It was 2012, now it's 2018. In Article 13, it prohibits the mediator from later post-mediation acting as an arbitrator. But there's nothing in the model law there that prohibits an arbitrator acting as a mediator in the course of the arbitration. There's nothing to prohibit that. And I think this is also because being a model law, it also has to take in the civil law and common law concepts into play. Yeah. So here is a recognition of that dichotomy, between common civil law, or the conflict, a tension between the common and civil law countries. I spoke too much on this question, sorry. But because Mr. Sriram was very energized on it, I think I have to respond with a little bit more energy than before. Thank you.
Thank you, Professor Wu. Judge Simac, would you want to add to this question?
Yes, I would agree with Professor Wu. So we all lawyers are overburdened with the huge baggage of thinking like a lawyer. Starting from the enforcement issue, which is actually doesn't exist in the world of disputants. It exists only in the world of lawyers. So people don't need enforcement clauses. They need agreement. They need the end of the dispute. And everything what is related to mediation is not binded by the strict law provisions, because it is not a legal procedure. It is acting in the shadow of the law, and the law is important at the end of the shaping of the agreement. But so last 2 or 3 of my arbitrations, So I see arbitration procedure much more flexible than my role of the judge litigator. Even I am much more flexible as a judge in the courtroom. So my 3 last arbitrations ended with the settlement, and I didn't use a mediator. At some point, when we have collected everything I need to decide, we started to talk how to reach a settlement without my decision. And believe me or not, I started to act as some kind of mediator, and they made settlements, and they said respect and thank you very much for the support. Of course, it is not possible when you don't see signals from the parties that they are ready to do it. But when they are ready to do it, do not afraid of step above your former role. Thank you very much.
Thank you, Judge.
Advaitha,
Ajay, I believe now we
can
should.
you come in for a minute?
Yes, ma'am.
I
Sure,
had
sure,
forgotten.
please, ma'am.
No, when I was mentioning Gandhi as the first mediator in the Indian context, I had forgotten the name of the book which I had read. That was Simon Pantabrick, and is of 2008. So just for people who may be interested in that.
Sure. Thank you, ma'am.
I
Ajay.
think we have some time for a
Yeah.
few questions. I know we've overshot our time, but I think the webinar system does allow us another half an hour to actually to go on, subject to what the speakers. I'd like to continue at least for another 10-15 minutes so we can have some interaction. I see that the discussions are getting a little animated and a little more exciting at this point in time. So I have a question now for Mr. Panchu now. Mr. Panchu, India does not have a mediation statute, a separate mediation statute as such. It has been argued by a lot of people amongst the mediation community in India that we need to have a mediation statute if this process has to be taken seriously at all. So what are your views, Mr. Panchu, on the necessity of having a separate mediation statute in India? Mr. Panchu, I believe you're muted.
Yeah, we don't have a mediation statute, you're right there, which is not to say we don't have legislation. We do have it, but it's in scattered bits and pieces all over the place. There's something in the company courts, there's something in a family court, there's something in the CPC, there's something in the ID Act. It's all over the place. It's uncoordinated. It's not systematic, and it's not modern. You know, it doesn't reflect modern trends. It doesn't reflect modern needs. So yes, there is a strong case that we need a mediation statute, a comprehensive one, a standalone one, and which is framed taking into account the needs of mediation, not fitting in mediation as some small plot, in some other context. So I'm happy to say that the work is, this is there. It's engaging the attention of those whose attention has to be engaged. So I hope very soon India will have a good mediation statute.
Excellent. Thank you, Mr. Panchu. And now I have a very interesting question for Justice Maushami Bhattacharya. Now, Justice Bhattacharya, this is a Miss Universe type of question. Post-retirement, Justice Bhattacharya, if you were given an option to work exclusively as an arbitrator or exclusively as a mediator, which option would you choose and why?
Ajay, I think you must bear in mind that Justice Bhattacharya's retirement is a long, long time away.
No, I was actually thinking on a different line, Mr. Panchu. I was thinking that you can also put it as a Mr. Universe kind of quest, isn't it?
I was coming to that, Judge. I was coming to that. Please.
Well, and I think for any of these pageant questions, you don't have a category of none of the above. I take it as presumed. But well, really, I would, given a choice, I would probably settle in for something which looks at as the end of a dispute, eradication of a dispute, as opposed to end of a list, but within some sort of a statutory framework, so that it can also give it a seal of enforcement, and that is entirely for the benefit of the parties, so that they don't have to keep running from pillar to post, from forum to forum, trying to get some sort of an enforcement of whatever decision is given.
Thank you, Justice Patacharya, for a very witty answer. Now we move on to Professor Lawrence Boo. So I have a question for you now. With the coming into force of the Singapore Mediation, imminent coming into force of the Singapore Mediation Center, do you think that the fortunes of these hybrid processes will decline? Your view, sir.
Thank you. I think I have earlier mentioned that the hybrid system is to help, at least the AMA system is to help the enforcement process. I think with the Singapore Mediation Convention coming into force, I think the AMA process will outlive its life and usage. So it's a natural thing. Yeah. As I said, it's a temporary measure to bridge that gap. So I think once it comes into force, and with more and more countries actually not just signing on, I hope ratifying it, it will be, and also if more and more countries adopt the mediation model law, and that will also take care of the enforcement issue. A non-issue will be taken care of, and you'll really be a non-issue.
Thank you, Professor Boo. I'd like to get Mr. Panchu on board now. Mr. Panchu, you've had a fair bit of experience with MEDAP now. Could you give our audience an insight into some interesting experiences of novel and innovative uses of the MEDAP procedure that you have adopted or you have been part of?
I'll tell you one which is very novel, so novel that Lawrence is going to pull my leg every time I sit with him on a platform. Having just said that, arbitrators shouldn't be mediating, I had a case referred to me by Justice Iqbal when he was Chief Justice of Madras under Section 11 of the Arbitration Conciliation Act. He appointed me as the arbitrator. And when the parties were leaving the court, he said, tell Mr. Panchu also that I want him to mediate. And he came and told me this. And I said, how am I going to do this, If I'm the arbitrator, how do I mediate? It's not possible. But Justice Iqbal or Justice Iqbal, I knew he'd ask me on another occasion, what have you done in that matter? So I said, so we applied our minds and we came up with something which I found very interesting. So let me very quickly tell you what happened. Essentially, the case is about a lady who had agreed as part of a family arrangement to give up her rights to a family property, which had been turned over for development. And she signed this along with her sister and other members of the family. The building had got built. The flat owners, had paid. They were all ready to occupy. The lady then came to the conclusion that she hadn't got her proper share. So she cancelled the agreement. She cancelled the power of attorney. She wrote to the development authority saying that I'm revoking my consent. You cannot give them a completion certificate. She threw everything into a tailspin. So the developer, the other members of the family, and the flat owners joined together. They sued her for specific performance and for damages. Invoked an arbitration clause. I'm the arbitrator. The lady has a useless case. She's out of time by limitation on several counts. There's no way, one can save her. But I think she has a point. But I can't do anything about that. This is a open and shut case in limitation. So I reduced the damages to 20 lakhs, 20 million, whatever. 20 is a figure I'm dropping. So she has to sign all the documents. She has to pay 20 million as damages. What we decided in deference to Justice Iqbal was that I would write my award and I would bring it to the table in a sealed envelope. And I would then ask parties to say, look, here is my award. It's in a sealed envelope. Do you want to talk mediation? If you do, you can. And confidentiality is not breached because nothing you say is going to affect this award. If you don't agree in mediation, I will release the award. If you agree in a mediation, I will tear up the award. And your mediation settlement will then govern. This is all just but otherwise I wouldn't have done it, mind you. So we agreed on this procedure. So I came with the award in the envelope, and they said, yes, we want to talk settlement. You won't believe what happened next. I called in the builder and I said, what do you think about this case, confidentially? And he said, sir, I've always known that she wasn't getting a fair share. But he said, it's not my problem. I'm only the developer. But I want to tell you one thing. This is my son's first, enterprise with me in our business. He has a long career. I don't want him to start with a black name, black mark. I'm willing to give her 25 lakhs. I called in the nephew and I said, just answer one question. If this was your mother instead of being your aunt, would you have the same response to her? I know, Lawrence, I'm supposed to be facilitative. Sometimes I cross a little bit of a line. I said, would you have the same response? And he said, sir, give me a little time. Within half an hour, builder, nephew, and flat owners came back and they said, between us, we are prepared to give her 50 lakhs. Now, here is this lady at 10:30 in the morning in my arbitration award. She is 20 lakhs down. At 12:30, because of a mediation which opened up a completely different set of questions and examinations and emotions, she's 50 lakhs up. And that underscored one thing to me, that you can have completely different results in a mediation and arbitration. But I advocate caution. When I tell people about this novel experience, I say, please don't think it should be the norm, because you have to be both a good arbitrator and a good mediator. If you're not, you will just push parties to accepting your arbitration award. So be very wary about adopting this. But I must also tell you, in every case I've arbitrated since then, I've had the parties ask me, sir, will you try your method when this is over? Give us a chance. And it's worked in every case since then.
Mr. Panchu, if you allow me to review a little bit on that, on the story, there was this case of Halsey versus Milton Keynes, I think sometime in 2004, where Article 6 of the European Convention of Human Rights was discussed, and said that really, I mean, a discussion whether a court can take away a party's right of going to court and say that no, you have to go to mediation. That was really one of the interesting aspects in that decision.
Right. It's tough. I mean, a party has a right to say, I want to go to court. I don't force me to settle in mediation. I think the norm we're adopting in India is the right one. We're only telling parties, we don't insist that you settle in mediation. We insist that you attend the first session. Get to know about mediation from a trained mediator. If after that you don't want to mediate, you don't have to. You can come back to court. We don't penalize you, which I think is a good way to go. Most cases I find that people initially reluctant, when they listen to the process, they're willing to give it a try. And I think that's a good way to go, actually, not to force them too much.
Thank you.
Ladies and gentlemen, I think we've totally run out of time. And may I now invite, it's been a fascinating session. Thank you so much for making it so interesting. May I now invite my colleague Advaitha to please deliver her closing address, please.
Thank you, Ajay. After, I believe, this intellectually stimulating session, it can safely be stated that articulating mediation and arbitration proceeding is neither a mission impossible nor a piece of cake. Instead, they are those frenemies which can be used alternatively, sequentially, conjunctively, or as a combined process to churn out the ultimate desired result, that is resolving a dispute. The use of hybrid clauses in agreement may be a way to contractually acknowledge and amalgamate the two processes which inherently are distinctive. With the flexibility of mediation and binding nature of arbitration, such clauses can result in a win-win situation for both the parties whilst maintaining their commercial relationship. Today, we see that mediation, just like arbitration, has now gained the due credence, not only in India, but in various other jurisdictions. In nutshell, despite the few bottlenecks discussed today, it can safely be assumed that these frenemies are definitely the way forward. On that note, I would quickly thank the illustrious panel, Honorable Judge Simac, Justice Moshmi Patacharya, Professor Lawrence Bu, and Mr. Sriram Panchu, sir, for your willingness to share your time and expertise in the area, which was critical for the success of the event. I would like to further thank Mr. Gaurav Banerjee for being part of today's webinar and agreeing to deliver a valuable introductory remark. And of course, my co-moderator, Ajay Thomas, for his efficient management of the session. And last but not the least, my attendees for their enthusiasm and participation. Apologies for the many questions that could not be addressed due to paucity of time. On that note, I would say stay home, stay safe, and have a great day to everybody. And I would like to conclude the session. Good day.
Thank you very much.
Thank you.
Thank you.
Are we done?
Yeah. Are we done?